Okay, welcome back to part 2. So now we're going to discuss a little bit more about what actually constitutes criminal responsibility. Okay, so first of all, we're going to discuss criminal responsibility. Now, some of this is going to be revision from what you did in 10-12 with Greg, but it never hurts to have a little bit of revision. So there are 4 elements that are generally required for criminal responsibility. And I'll just turn the page away from it, but I should be able to do it by heart. I do know it. Okay, actus reus. Defendant committed the illegal act. Was it that person who actually physically committed the act? So it is the action of committing the offence. Mens rea is about intent and guilty mind. Did they mean for it to happen? Was there intent? What crime do you always have to prove mens rea? Of course, it's homicide. What is it called if it can't be proven? It's called manslaughter. Okay, hopefully you knew those answers before I said them. Causation, whoops. Actions of the defendant must have caused the prescribed consequences. So for instance, if there's a fight, but the victim has a brain hemorrhage 3 days later, was it caused by the fight? So the actions of the defendant must have caused the consequences. And the absence of defence. So the defendant must not have any acceptable legal defence, such as insanity. Diminished responsibility. The defendant not criminally liable due to an impairment in mental functioning. So they were in a state of abnormality of mind such that they could not understand that what they were doing was wrong. In this, diminished responsibility in the UK and in Queensland can only be used as a defence in murder trials. So if the mental health court finds diminished responsibility in a case of murder, that charge will be discontinued, but other offence to which the proceedings relate may be continued. So the charges may be dropped to manslaughter. Claims may be supported by psychiatric or psychological evidence of a mental disorder. So looking back to what was going on at the time they committed the offence. An insanity defence is a legal concept. It is not a psychiatric definition. A psychiatrist will not tell you you are insane. So it is a legal concept. Successful insanity plea is just when the person is considered incapable of knowing the difference between right and wrong at the time of the crime. Now, very few people will meet this criteria. It is really actually very difficult to meet the criteria. So, for instance, the fellow in Melbourne about 3 or 4 years ago now, who drove his car up onto the footpath and killed 6 people, tried to get a insanity defence, and he was unsuccessful. So he was tried and he is now serving 6 life terms. It is very, very difficult to get an insanity defence. M'Naughton's rule came from the 1800s. So M'Naughton was one of the first cases in the 1800s to have a plea of insanity accepted by the court. His issues were very similar to Ralph's, as he believed that the government was out to get him. He was a paranoid schizophrenic. So it's all about the person not being criminally responsible if they did not know the nature and quality of the act that they did, because the presumption is always there that everyone who comes before the court is sane. So it is about the concept that the defendant was suffering a disease of mind, incapable of knowing that what they were doing was wrong and that it was morally wrong. It has been criticised for being too narrow and not providing for degrees of incapacity. So what are the consequences? Well, a person can be found to be of unsound mind. The proceedings can be discontinued. And if they're not unsound, then the matter will be returned to the criminal court. So if it goes to the mental health court, they're not found to be of unsound mind, the matter will be referred back to the Supreme Court or the Magistrates Court to be dealt with in the normal procedure that happens there. If they are found of unsound mind, the mental health court can make a forensic order to detain them for treatment or care. Now, they can be contained or detained in this highly secure unit for a very, very long time. So when you hear people saying, oh yeah, I bet they're going to go for the insanity plea so they get off, if they are found to not be understanding what they did, the actual punishment can be very, very severe because they can be locked up for a very, very long time. If they have a community treatment order, so not in a secure unit but can live in their home, then it would be considered that they're not actually that dangerous because their level of dangerousness would be taken into account. But they would still have some very, very strict criteria placed upon them when it came to where they could or could not go and who they could or could not have contact with, and also about attending appointments. They may not be able to drive. There would be a lot of things going on that would severely limit them leading a normal life. Okay, so going back to Ralph, and I forgot to highlight this one and turn it into black, so I shall just do that now and move this down so we can see it. All right, so during his trial, the prosecution argued that while he was mentally ill, he did not meet the legal criteria for insanity. But he walked around thinking he had a microchip implanted in his penis and hearing voices telling him what to do, but he didn't meet the legal criteria. He was found guilty and sentenced to the maximum term of 20 to 47 years and incarcerated in a maximum security prison. And he not only was in this maximum security prison, he just absolutely moved back and forth between the maximum security and the mentally ill offenders unit, just back and forth. So he'd get treatment, they'd say, yeah, you're fine, put you back into the real life, normal prison. He'd break down again, they'd put him back. And this went on for 3 years. And he eventually succeeded in committing suicide. Now, this YouTube clip, I'm not sure if it is there. If it is, fantastic, but I think it's probably disappeared. But so I'll just tell you what's in it. The lady that's in it was the prosecutor who served on Ralph's case and was responsible for him going to jail. And she simply talks about the fact that since the case, between when the case ended and when Ralph died, she also lost a child, and she felt very differently about what she did to Ralph after losing her own child. Could this have been handled better? Well, obviously it could have. He was never fit to stand trial. Both sides and the judge should have decided he was not fit, and he should never ever have been sent to a normal prison. So what are our statistics in Queensland courts? Well, the number of people that go through mental health courts is really, really small. Okay, I know this is now 10 years old, but it hasn't really changed in looking at how many go through mental health courts to how many go through the normal courts. So if you look at those figures, 178,500, and these are a little bit higher now. So that's what goes through those courts. And let me just have a look at something here. So if you think about those sheer high numbers there, and look at the same time for the mental health court, 12 references for murder. 2 of those resulted in a finding of unsound mind and a forensic detention order. 1 resulted in diminished responsibility, and the remainder, the reference to the mental health court, was either withdrawn or they were referred back to the Supreme Court to proceed with the trial. So in that time in Queensland, there were 98 defendants for homicide. This was what was found: 55 guilty, 21 acquitted, 22 withdrawn by the prosecution. Only 12 out of 98 were referred to the mental health court. So it really is quite small, and it is very, very difficult to get a finding of unsound mind. So the take-home message, they're rare. If it is referred, the majority do not result in a finding of unsound mind, at least for murder. So what have we learnt today? Well, the relationship between mental health problems and crime is really complex. There are a lot of confounding factors that can lead to people with a mental health problem committing crime, but overwhelmingly, the vast majority of people who do have a mental health problem do not commit crime. Competency to stand trial is not consistently applied, so allowing a trial to proceed where the mental competence of the defendant has not been established can lead to problematic outcomes, and defences such as diminished responsibility and not guilty by reason of insanity are rarely used successfully in a Queensland context. Okay, so that finishes off mental health and offending. In week 10, we are moving on to juries and decision making. So we will talk again then.